We're today at Sodoma Law talking to Sarah Bennett, managing attorney. We're talking about the difference between mediation, arbitration, and litigation, and which one you should go with. Thank you so much for sitting down with me today.
It's so nice to see you.
Yeah, so let's jump right in. Let's talk about mediation. Explain to me what that is and if you have to be there for that.
Absolutely. So mediation is where a couple decides to use a third-party neutral, so a trained mediator that's going to help facilitate them trying to reach a resolution together on a particular issue. So in North Carolina, you are required in domestic cases to mediate certain disputes. So anything involving custody and equitable distribution, you're probably going to have to go to mediation for, with some exceptions here and there.
And then arbitration.
Arbitration, yeah, so we're kind of stepping up in terms of formality.
Okay, so they're kind of like a step stool. Okay.
Exactly, so mediation is the least formal and you have the most control over the process. Okay. So arbitration, you are selecting an arbitrator, so again, it's a third-party neutral, and you're presenting your case to the arbitrator. So in a mediation, your decision, nobody's the decision maker except for you. In arbitration, the arbitrator is the decision maker. So it's kind of like having a trial but at a conference table. So a little less formal than the actual litigation process, but you're still guaranteed to have a decision at the end because the arbitrator is going to make it for you.
Well, we're talking about the step stool. We're going up to the next one. Litigation is the next one. So this is kind of the most formal part of this.
Absolutely, and certainly the most adversarial. Mm-hmm. So litigation, it's also going to be the most time consuming. This is, when you watch TV and you see someone in a court battle, that's litigation. It involves filing a complaint. The other party is going to file their answer and potentially counterclaims to that complaint. And then you're going to have motions in court, discovery. It's a really time-consuming, emotionally exhausting, and sometimes expensive process.
Right.
So,
3 different steps here. Again, like we said, there's a different level of involvement in each one. I mean, what are the advantages and disadvantages of going all the way and going to court to settle these things?
So when you're dealing with someone that might be really difficult to make decisions with, you might need a court or an arbitrator to make a decision for you because we're just not going to get there on our own. However, the mediation process is very successful generally. It doesn't sound like it would be. The mediator's kind of bouncing between your room and your spouse's room until you reach an agreement. But that, like I said before, it's going to give you the most control over the situation. And in the domestic context, we're fighting about our kids, we're fighting about our homes, we're fighting about our money, we're fighting about our future. And that's a situation where you might not want to have some third party, a judge or an arbitrator, making a decision for you.
Cost is a huge factor to this. So the higher up you go, the more you're going to be paying.
Absolutely. It kind of seems counterintuitive because you have to pay the mediator, you have to pay the arbitrator, but generally you're going to be splitting those costs with the other party that's participating, and you're going to get in faster. So when it's faster, you're spending less hours, and thus it's going to be less costly for you.
Very good information. Thank you for differentiating that for everybody and giving them the information they need. SodomaLaw.com is where you can find more information. Really appreciate you.
Thank you.